David Everist, and I'm going to be starting a show called Keeper of the Republic at UCY TV, and the name of the show will be Keeper of the Republic by Minor Dave Show. And tonight, right now, I'm going to do a little segment for YouTube. I filed a tort yesterday, the 6th of January 2014. I filed it somewhere between 9:30 and 10 o'clock in the morning, maybe a little later, at the U.S. District Court in Medford, Oregon. I'm filing a government-to-government tort under the FLIPMA laws. Gives me my right as a mining claim, a township, a mining district, and an unincorporated city, with lots of rights here. One is I have a possessory title in a trust, in a grant granted in 1872 to American citizens, or United States citizens. And you have a right, where found, to file a claim. You have the right to entry and egress and ingress. And so you can do this. And since I'm going to cover more of the trust law here, this is a grant given by Congress to the United States citizen, and they formed it into a trust. And the BLM is the manager of where you file your paperwork and where you file your paperwork for maintenances and pay certain fees and stuff. And then you have maintenance to do to maintain your claim on a yearly basis. And that gives you a possessory title until you perfect it, where you have ultimate title. By the way, the mineral estate is the dominant estate. It rules the roost. But anyway, so as having a patented claim versus having an unpatented claim, you have primary title, you have possessory title. And as me having a possessory title, I have maintenances to file every year and certain fees to pay. And I prefer to perform the work or have the work done. And there's lots of things that count for work that you can enter into the record. In fact, government-to-government coordination is one of those things I can put in as assessment work. But anyway, so the BLM is supposed to have a trustee. I've been under my government-to-government coordination. I did a notice on more of a demand for government-to-government coordination to find out who the trustee is with the director of the Medford BLM, United States Department of Interior. He's the director here. He can make decisions. He's supposed to talk to me under government-to-government coordinations and arrange certain meetings. And we get to exclude the public on this. This is my government with his government coordinating property rights here and what their regulations can and cannot be. Now, we can't stop them from making a regulation, but if they do a regulatory takings, they have to pay for it. And if they've infringed on the patent for trying to get me, inhibiting me from perfecting my claim so I can get rodeo title and without any encumbrances from anybody, not even the state or the county, because it would be within my jurisdiction and jurisdiction control under my mining claim township, mining district, and unincorporated city. I would have home rule. I would be the controlling legal authority. So as the controlling legal authority, I have a right to prosecute the mining law. But so what I'm trying to do is just get a seat at the table so I can coordinate the takings implication assessment that falls under an executive order, because back in somewhere around the 80s, the Federal Circuit decided a rancher's case, and they decided to make great many cases that led to the executive order and Congress approving it for a takings implication assessment that all the agencies are required to fill out, even under the Paperwork Reduction Act. The government employees are required to fill this form out. And that was never done in this case or any other miner's case, and it goes back for a long ways, because they've had judgment after judgment after judgment, and they still do the same thing over and over and over again. Well, this is criminal, is what they're doing, and the director, Dina Bierman, shall contact me and tell me who the trustee is, or the lack thereof one, and admit that it was a mistake, and beg the miners' forgiveness, and compensate all the miners for the lack of this. And the miners will get together and appoint the trustee that will defend it. And then I asked them to come and defend it, because see, this is being brought against me through a public-private partnership, through economic development, nonprofits, and environmental groups. They're nonprofits that sue the government because they've made themselves fake stakeholders or fake claimants. This is a fraud, and it has to stop. And I plan to do this through the government-to-government coordination, because see, I get to exclude all those groups, and only the governments can be here. The nonprofits, they claim to be governments, but they're not. And I can get them excluded from these coordination meetings. And I plan to have these coordination meetings ordered. Now, when I filed this tort, the clerk showed me a form. She was trying to figure out which one I check. And I said, well, this is property issues. It would be patent infringement. And I go, because it's not copyright, and it's not intellectual copyright patent. It's patent of land. It's a different form of patent, but it's still a patent. And then you have trademark and under property laws. And so property is considered a thing, and a thing could be anything. And so that's why you have intellectual property laws on musicians' recordings, their intellectual property, and there's a good need for it. This intellectual property should be protected. It's not being done correctly right now, because there's actually people that are abusing it. But if you want to build something, you can form trademarks, and you can either do licensing for your trademark or licensing to build the product, but whatever. So there's lots of ways to make money off this. But now getting back to the grant, the trust, where they pass title to the American citizen for him to come out and accept the treaty, the grant, the compact. It just means contract. And so when a person files on said claim, it's now no longer public reserve. It becomes publicly domained land that can pass through the exclusivity of the mineral claim. Now, if other lands are available for disposal, like national forest lands or agricultural lands, they could sell the forest off. They just can't sell the minerals off, because they're already owned by the American citizen. For the United States citizen to come file on. That's what I did, and I filed it in the reserve, which it pulled it out of the reserve and made it publicly domain land. These are mineral lands. There was many claims filed on this one in many different ways. And so this has been part of a bigger claim, a smaller claim, a larger claim. And so right now it's my claim, and I plan to defend it vigorously. And this is the end of this show for now.